Good morning. Before we begin, I want to acknowledge that we're gathered on the traditional unceded territory of the Algonquin Anishinaabe people. I want to honor the many First Nations, Inuit, and Métis whose lands we visited during this investigation. I want to acknowledge the courage of survivors whose voices are at the heart of this report. We believe you. What happened matters, and it's not your fault. Please take care of yourselves and reach out for support if you need it. I'll introduce our team here before talking about the contents of the report. On my right, we have Huri Hamboyan. She was the lead investigator. Huri compassionately interviewed more than 100 survivors and supported all parts of the investigation. To her right, Miriam Moose works with our policy team and helped to bring expertise and policy and research background into different chapters of the report. On my left, Pamela Arnott is our general counsel and provided legal expertise to the team. And to her left, Aisling McCoy also works with our policy team and helped to support data and other parts of the report. Je vais d'abord m'adresser à vous en anglais et je vais répéter mes remarques en français ensuite. Sexual violence remains one of the most underreported crimes in Canada. Despite decades of reform, only 6% of sexual assault survivors report to the police. Too many survivors told us that when they came forward, they were disbelieved, re-traumatized, and further harmed. Too many described their experience with the criminal justice system as more harmful than the sexual assault. Today, the Office of the Federal Ombudsperson for Victims of Crime is releasing Rethinking Justice for Survivors of Sexual Violence, a systemic investigation. Over 18 months, through interviews, surveys, virtual roundtables, and site visits, we engaged with nearly 3,000 people across Canada: survivors, service providers, police, Crown attorneys, defense counsel, judges, and community leaders. We reviewed academic research and more than 750 court cases and 300 media articles. The message was clear. Survivors are silenced by myths and stereotypes that persist in courtrooms and police stations. They're re-traumatized by invasive cross-examinations and the threat of having their therapy records exposed. They feel abandoned when cases are stayed under R.V. Jordan, leaving them without justice after years of waiting. One survivor told us, "I don't think there's anything worse for a victim than to have a trial stayed." Behind every statistic is a person, a life interrupted, families and communities affected. Survivors describe feeling like evidence and not human beings. And yet, despite these barriers, survivors do come forward, not for themselves, but to protect others. 97% of survivors who reported in our survey did so to prevent the perpetrator from harming someone else. That is an extraordinary act of courage. And there has been progress in Canada. Across the country, police services are adopting trauma-informed protocols. Courts are using testimonial aids more often and rejecting myths and stereotypes about sexual violence. Communities are creating culturally safe support. And independent sexual assault centers, who've been doing this work much longer than I have, are continuing to offer survivors safety and hope. Throughout the criminal justice system, there are people working hard and working with compassion to support survivors, but there remain systemic barriers that need to be addressed. We can better protect survivors while we respect the rights of the accused. We can lower costs, save time, and reduce charges from being stayed or withdrawn. Our report, Rethinking Justice, contains 43 recommendations. Together, they map out a practical, evidence-based roadmap for reform. We need to end harmful practices like KGB cautions that treat survivors like suspects. Protect therapeutic and counseling records so survivors never have to choose between mental health and justice. amend the criminal code to ensure that delay applications under R.V. Jordan consider the rights and safety of victims. Guarantee enforceable rights under the Canadian Victims' Bill of Rights, including access to independent legal advice and testimonial aids. Invest in culturally safe, trauma-informed services that meet the diverse needs of survivors. And expand restorative and transformative justice options, giving survivors real choices beyond the courtroom. This is not just a legal issue. It's a human rights issue. Survivors have charter rights to life, liberty, and security of the person, and those rights must be respected. We can do better. Responses to sexual violence test the fairness, compassion, and accountability of our institutions. Survivors deserve a system that protects their dignity, their safety, and takes responsibility for not causing more harm. Today, I'm calling on Parliament, on policymakers, and on every Canadian to join us in rethinking justice. Let's build a system that doesn't re-traumatize survivors, but restores trust. A system that's fair to everyone involved and looks a little more like justice to the people who've been harmed. Because sexual violence has no place in our society. This is not the first report on sexual violence and criminal justice. For decades, survivors and advocates have called for change. While there has been progress, many recommendations have gone unanswered. That history matters, but it doesn't define our future. Our Ombud Office has authority to require a government response to our recommendations, explaining what action will be taken and why action will not be taken. This promotes accountability to the public and transparency. We have a lot of hope that together we can choose a good way forward. Change will require leadership, coordination, and courage, but it is possible and it is necessary. Je continue en français. Au début, je tiens à saluer le courage des survivantes et survivants dont les voix sont au cœur de ce rapport. Nous vous croyons. Ce que vous avez vécu compte et ce n'est pas votre faute. Prenez soin de vous et n'hésitez pas à demander du soutien si vous en avez besoin. La violence sexuelle demeure l'un des crimes les moins signalés au Canada. Malgré des décennies de réformes, seulement 6% des agressions sexuelles sont signalées à la police. Trop de personnes survivantes nous ont dit que lorsque se sont manifestées, elles ont été discréditées, revictimisées et blessées par le système censé les protéger. Trop d'entre elles ont décrit leur expérience avec le système de justice criminelle comme plus traumatisant que l'agression elle-même. Aujourd'hui, le Bureau de l'Ombudsman fédéral des victimes d'actes criminels publie « Repenser la justice pour les survivantes et survivants de violences sexuelles », une enquête systémique. Pendant 18 mois, grâce à des entrevues, des sondages, des tables rondes virtuelles et des visites sur le terrain, nous avons échangé avec près de 3000 personnes partout au Canada. Des survivantes, des prestataires de services, des policiers, des procureurs de la couronne, des avocats de la défense, des juges et des leaders communautaires. Nous avons analysé des recherches universitaires, plus de 750 décisions judiciaires et 300 articles médiatiques. Le message était clair. Les survivantes ont réduit au silence par des mythes et stéréotypes qui persistent dans les tribunaux et les postes de police. Elles sont revictimisées par des contre-interrogatoires invasifs et la menace de voir le dossier thérapeutique exposé. Elles sont abandonnées lorsque des causes sont arrêtées en vertu de R contre Jordan, les laissant sans justice après des années d'attente. Une survivante nous a dit « Je ne pense pas qu'il est pire pour une victime que de voir son procès abandonné. » Derrière chaque statistique, il y a une personne, une vie bouleversée, des familles et des communautés touchées. Les survivantes ont décrit le sentiment d'être traitées comme des preuves et non comme des êtres humains. Et pourtant, malgré ces obstacles, les survivantes se manifestent, non pour elles-mêmes, mais pour protéger les autres. 97% des survivants de notre sondage qui ont signalé l'agression l'ont fait pour empêcher l'agresseur de nuire à quelqu'un d'autre. C'est un acte de courage extraordinaire. Et il y a eu des progrès. Partout au Canada, les services de police adoptent des protocoles adaptés au traumatisme. Les tribunaux utilisent plus souvent des mesures d'aide au témoignage et rejettent les mythes et stéréotypes sur la violence sexuelle. Les communautés créent des solutions culturellement sécuritaires et les centres d'aide aux victimes d'agressions sexuelles qui font ce travail depuis bien plus longtemps que moi continuent d'offrir sécurité et espoir aux survivants. Nous pouvons mieux protéger les survivantes, respecter les droits des accusés, réduire les coûts, gagner du temps et éviter que les accusations soient abandonnées. Notre rapport « Repenser la justice » contient 43 recommandations. Ensemble, elles tracent une feuille de route pratique et fondée sur des données probantes pour réformer le système. Nous devons mettre fin aux pratiques nuisibles comme les avertissements KGB qui traitent les survivants comme les suspects. Protéger les dossiers thérapeutiques pour que les survivantes n'aient jamais à choisir entre leur santé mentale et la justice. Modifier le code criminel pour que les demandes de suspension en vertu de R contre Jordan tiennent compte des droits et de la sécurité des victimes. Garantir des droits exécutoires en vertu de la Charte canadienne des droits des victimes, y compris l'accès à des conseils juridiques indépendants et à des mesures d'aide au témoignage. Investir dans des services adaptés au traumatisme et culturellement sécuritaires qui répondent aux besoins divers des survivants. Et élargir les options de justice réparatrice et transformatrice offrant de véritables choix au-delà du tribunal. Ce n'est pas seulement une question juridique, c'est une question des droits de la personne. Les survivantes ont des droits garantis par la Charte, des droits à la vie, à la liberté et à la sécurité. Et ces droits doivent être respectés. Nous pouvons faire mieux, moi aussi. Les réponses à la violence sexuelle mettent à l'épreuve l'équité, la compassion et la responsabilité de nos institutions. Les survivantes méritent un système qui protège leur dignité, leur sécurité et qui prend la responsabilité de ne pas causer plus de tort. Aujourd'hui, j'appelle le Parlement, les décideurs et chaque Canadien à se joindre à nous pour repenser la justice. construisons un système qui ne revictimise pas les survivantes, mais qui restaure la confiance. Un système équitable pour toutes les parties et qui ressemble un peu plus à la justice pour celles et ceux qui ont été blessés. Ce n'est pas le premier rapport sur la violence sexuelle et la justice criminelle. Depuis des décennies, les survivantes et les défenseurs réclament des changements. Bien qu'il y ait eu des progrès, de nombreuses recommandations sont restées lettres mortes. Cette histoire compte, mais elle ne définit pas notre avenir. Notre bureau a le pouvoir d'exiger une réponse du gouvernement à nos recommandations, expliquant quelles mesures seront prises ou pourquoi elles ne le seront pas. Cela favorise la reddition de comptes et la transparence. Nous avons beaucoup d'espoir qu'ensemble nous pouvons choisir une voie juste. Le changement exigera du leadership, de la coordination et du courage, mais il est possible et il est nécessaire. Je suis maintenant prête à répondre à vos questions, en anglais ou en français.
Peter Zimonich with CBC's Parliament. I had a question about, the report seemed to be suggesting that there was a lack of reporting was in many ways tied to a lack of confidence in the justice system, and I was wondering if you could expand on that notion of how important that confidence is.
Thank you. In our report, we held a survey for survivors of sexual violence, and we had 1,000 responses. Roughly half had reported to the police and roughly half had not. And so we asked questions about reasons that people had not reported to police. And one of the strongest reasons that people indicated most often and that was most likely to affect their decision was seeing how other survivors have been treated in the criminal justice system, that was the largest barrier to reporting. And so we know that there's work to do to make the system feel safer for survivors and to provide real alternatives. If only 6% of people are supporting it, doesn't mean that the others don't want access to justice, but they might want options that look different than the current system, which is why we have a chapter that looks at restorative and transformative justice, really carefully looking at how to offer those options safely and in an evidence-based way that supports consent and survivor-driven process.
Just to follow up, you have quite a powerful comment in your opening to this report saying that you believe the justice system is in open disrepute. But you also say that there's some improvements have been made. Somebody out there in the world who's maybe thinking about reporting something that's happened may be confused by those messages. Are you telling them that there's no point in reporting something now because it's an open disrepute, or are you saying, yes, report something, and how can you just maybe clarify your approach to it, your message to people who are considering reporting?
We're bringing forward the voices of survivors in a systemic investigation so people can see what's happening. One survivor we interviewed talked about choosing to report knowing that it would be a difficult process, that it could cause harm, but doing it to protect the public. And it's a sacred trust that people are putting in the system. And I do honor the fact that there are many good-hearted, effective people working across the system, but there are clear points that need to change so that survivors are better protected, and we outline very tangible ways that we can do that.
Parliament Wednesday having this press conference, there's a number of recommendations for the federal government in terms of changes to federal policy. What would you say is kind of the key recommendation? Is there one or two that you would most like to see the government do?
So we grouped the 43 recommendations into 10 big areas that we feel need redress. But at its core, we'd like to see enforceable rights for victims of crime. In the process, we treat a crime like it's against the state, and sometimes we forget the person who's been directly affected, and they can feel pushed aside or invisible, and like we described, feeling more like evidence than a real person. they have charter interests. And one of the things we'd like to see coming out of this report is better understanding of the charter rights of survivors. The rights of the accused, which are absolutely fundamental and need to be protected, are clearly mapped out in the charter. It's not as clear where those charter rights sit for survivors, and so we're inviting consideration of how those rights to life, liberty, and security can be better reflected, and to provide survivors with legal advice and legal representation when their charter interests are at stake.
In terms of changes to the criminal code or specific legislation, like in terms of like specific legislative changes, is there anything that you would like to see?
Yeah, we map out a number of things. We have chapters dedicated to different topics. So we'd like to see testimonial aids provided presumptively to survivors, so automatically. Right now, we're actually spending court time allowing the person who's accused of causing the harm to argue why a survivor shouldn't have access to protection in the system. Things like a support dog or testifying behind a screen or by CCTV. Those things matter, and evidence has shown us now at this point, it's quite clear that when people can participate more safely, it supports the truth-seeking function of the court process. You can provide better evidence. And so there's no justification in my mind to continue to deny survivors things that can help with the truth-seeking function of the court, which is the entire purpose. So we talk about that, and we also spend a whole chapter gathering evidence around the impact on survivors when their therapy records and counseling records are subpoenaed. We heard from survivors that it's a profound violation and a breach of trust when the federal government, who has responsibility for the criminal code, allows those records to be subpoenaed. There was a Supreme Court decision, RVJJ, that affirmed the constitutionality of the screening regime that we have in place to protect records. So there's a process when a record is requested where it's screened and it's not automatically admitted. Parliament has put those protections in place, and even so, we heard that when survivors have records subpoenaed, that they drop out of therapy, that they sometimes experience thoughts of suicide or suicidal ideation, and they're cut off from access to mental health support. That's a profound violation that disproportionately affects women's access to healthcare because of gender-based violence, and it needs to be addressed. The person who caused the harm shouldn't benefit from a survivor asking for help.
One of the recommendations says steps must be taken to better respond to the needs of Indigenous victims. I was hoping you can shed more light on that, and what specific steps are you referring to?
Thank you. The first recommendation in our report comes back to the calls for justice from the inquiry on missing and murdered Indigenous women and girls and gender diverse people. There's still action that needs to be taken. There's a need for trauma-informed working communities. There's a need for effective restorative justice options. There's a need for better access to sexual assault evidence kits, particularly in remote and northern communities, where we heard sometimes from Indigenous survivors that they might have to get in a taxi and travel for 2 or 3 hours to another community to have access to a sexual assault evidence kit. That's not trauma-informed, and the MMIWG inquiry already called attention to many of those issues. So we come back to them, we bring them forward because we're still hearing that those need action. And we have mapped out the entire investigation around the calls for justice so that we're bringing it forward again because it matters.
And as a follow-up, you mentioned that you would be seeking a response from the Justice Department. I wonder if you've had any chance of maybe meeting the Justice Minister or officials from his department to discuss the findings and what their response has been like?
Yeah, thank you. So the Ombudsperson is appointed to lead the Office of the Federal Ombudsperson for Victims of Crime, but is also appointed as a special advisor to the Minister. We're arm's length, we're independent, we don't take direction, but we can provide advice. And so throughout the investigation, we've been advising the Department of Justice and the Minister's Office and other ministers about what we've been hearing and which direction our recommendations are going so that they can be prepared to respond. Obviously, legislation and legislative proposals take time, but we're hopeful to see some action. And within 6 months, we'd like to see that response from government on what they're going to do, having received this report, so that they can be accountable to the public.
And could you tell us a little bit more about this issue of the trials being stayed because of R.V. Jordan? To what extent did you find that this is happening, and just any more information you can give us about that?
We have a chapter dedicated to the impact of the R.V. Jordan decision across the entire criminal justice system. So in 2016, the Supreme Court made a decision that the constitutional rights of the accused and the interests of victims are best served when justice is efficient and quick. And so there's two imposed deadlines, an 18-month window and a 30-month window, and the justice process is supposed to be completed in that time. And if it's not, then a case might be stayed, which means it discontinues or withdrawn. And so what we've seen since that decision has come out is that all kinds of decisions, from the decision of when to lay a charge right through to decisions about whether to continue with proceedings, are all affected by R.V. Jordan. So in 2022, 2023, sexual assault was 2.3 times more likely than other violent crime to have passed the Jordan limit and to be stayed or withdrawn. Right now, there's no guarantee in the criminal code that a survivor will even be notified of an application by the accused to stay the charges. And we know clearly in cases of violent crime that there are safety risks to survivors when a violent offense is dropped because of R.V. Jordan. And so we advocate for clear notification, for clear consideration of victim safety, like what is supposed to happen at bail. At a bail hearing, victim safety is supposed to be considered. And so we'd like to see a similar process under R.V. Jordan. And we also discuss alternative remedies that could be available. I know the government has an interest, and the public have been talking about the impact of R.V. Jordan. Some parts of the country are very affected by it, and it's leading to all kinds of cases coming out of the system, and some really aren't affected very much. We heard from some entire provinces or territories that it's not really an issue for them. And there has been lots of improvement in the efficiency of the system, but it's important that we're not putting survivors through a trial and cross-examination, the violation of their privacy and their mental health, and then dropping the process after they've been through that.
Is there anything that you'd like to see the government do to address that specifically? I know you just mentioned some things, but I'm just curious about really the federal policy piece of this.
Yeah, we believe that federal legislation can address alternative remedies. So it's not absolutely necessary that the Supreme Court would be locked into choosing a stay. Already within the measure, there's a provision to allow for extra time or consideration where there's complexity. One of the other areas we've identified is in the calculation of Jordan delays. Right now, when the timeline is set, there's an incentive for the defense to use optional measures like requesting counseling records and often the protections for victims of crime, because it adds more time. And so the measures that Parliament has brought in to protect survivors, if they're used, the survivor's case is more likely to be thrown out or ended. And that's a big contradiction that needs remedy.
A question on therapeutic records. The report calls for a tightening around access to those. I think a lot of people might find it pretty kind of amazing that someone's personal medical records, especially psychiatric records of trauma, could be introduced into court. I know in the background briefing we heard of a case of someone's dream being cross-examined. Could you tell me why you don't just call for a complete ban on that and wholeheartedly? Is there some reason in some small area where it's still useful? Or?
So the Supreme Court has said that there can be value at times to content in those therapy records. But what we've been seeing internationally and in Canada, this year there's 3 major reports on sexual violence, including ours. One is from BC, where Dr. Kim Stanton, who is part of the Mass Casualty Commission, recommends considering a class privilege, which would put it into the realm similar to attorney-client privilege. And a law reform commission in Australia says that their government should consider an absolute prohibition. What we've suggested, though we need to see some remedy, is changing the threshold from having probative value, so it might it's likely that it has some value to the case versus necessity. Is it necessary to argue the case? Because often those records are adding little value and they need better protection. People shouldn't be worried when they go to see a therapist that it can be used against them. And we saw in our report that more than 20% of the survivors in a survey of 1,000 survivors said that they wanted to access counseling but felt like they couldn't get help because their records could be subpoenaed.
Thank you. This concludes the press conference. Merci, c'est ce qui conclut cette conférence de presse.
Merci. Thank you.
Thank you.